My name is Don Gilbert, and I'm an attorney here at Sanchez and Associates. I like to talk about some questions that I get, some complex, some not so much, during consultations with clients. Oftentimes, a client will, or client-to-be, will come in and ask me if they can change attorneys. They probably already have an attorney and are considering changing one, but they don't know whether or not they can. The answer, of course, is yes. You can fire an attorney, and that's what we call it, at pretty much any time during the pendency of your case, in the beginning or towards the end. The key question that you need to ask yourself or ask us is, are the actions of your prior attorney something that are ineffective? We call that ineffective assistance of counsel. If you are being provided ineffective assistance of counsel, your telephone calls aren't being returned, you're being given advice that you know is not based in law or good advice in general, you can always fire the attorney. Procedurally, we do a stipulation to substitute that attorney for ourselves, and then we take over where the case left off. So the answer is yes, and that's a very simple thing that can be done very quickly. The other question that I get, strangely enough, quite often, and it's a little bit more complex, is what is the difference, and can I get an annulment? What is the difference between an annulment and a divorce? A divorce assumes that the marriage is valid, and if the marriage is irretrievably broken, a divorce is the measure by which you terminate that marriage. An annulment is a different thing. There is the question of validity, and the court has to be involved in either a divorce or the different types of annulments, and I'll explain what they are. But the question is the marriage valid? Was the marriage valid from the start? The question that you're going to ask yourself is, was the marriage void at the time of marriage? And in Latin we say ab initio, the initiation of the marriage, or can it be considered voidable? If it was void at the time of the marriage, there are a couple of factors that the court is going to look at. The court is going to decide whether or not there is consanguinity, and that would be, are you married to a relative? Is it a parent and a sibling that is married? That would void a marriage from the start. Is it cousins that are married? That would void the marriage from the start. So that's one thing that makes a marriage void. Bigamy is also something that makes the marriage void, and that is one of the partners, one of the spouses, already married to another. If that's in fact the case, that marriage is void from the beginning. And the third one, as far as initially a void marriage, would be whether or not there is mental incapacity, and that can be due to psychological difficulties, that can be due to the use of intoxicants, alcohol, or drugs. If that's in fact the case, and that person was under the influence to the extent that they could not validly consent to the marriage, and you may be thinking Las Vegas perhaps, then that marriage is void from the start. The second kind of situation whereby you can get an annulment is if the marriage is voidable, and that is certainly a different situation. The questions that the court is going to ask is one of the individuals that got married underage at the time of the marriage and did not have the parental consent to get married? That would be a voidable marriage. Was there duress or fraud that caused or coerced one of the spouses into getting married? If that's in fact the case, if there are facts that show that duress or coercion was used by one of the spouses to force the other spouse to get married, that would be a voidable marriage, and an annulment would apply. So it's a little bit more complex than a divorce, but certainly if any of those factors are involved in your marriage, come and see us because we can most certainly help you.